honor that I introduce Judge Rowan Wilson.
Well, this is great that this is outdoors. This is the longest I've been outdoors in I don't know how long. It's always a pleasure to be among members of the State Bar Association, and as President Lewis mentioned, I was here last year for the first ever civics convocation, which I thought was a real treat. And an event I hope the Bar Association will put on every year. I think it's something that is important if our society is going to survive in the way we'd like it to survive. I also wanted to thank the members of the dispute resolution section, in particular Jill Pilgrim and Jeff Anderson for that lovely introduction, and for letting me spend a few minutes to address you. It was very easy to get here. It is one building over. But because we're in session, it also means that after I finish, I can't linger. I've got to go. The judges are all having dinner together, and then I'm back to work. I've got 2 cases to report on tomorrow, and they're not near done. The oral arguments seem to have changed a few things that I anticipated. Many people think of ADR as a fairly modern concept, but in reality, it's quite old. Around 400 BC in ancient Greece, Athenian courts were growing crowded. Sounds familiar? So the city-state created a position that was called diaetetai, or public arbitrator. According to Aristotle, these arbitrators were selected from the body of course, male citizens who were at least 60 years old. Serving as an arbitrator was viewed as a serious and important public duty. If you were chosen as an arbitrator, you had no choice but to serve unless you were away from Athens or you held a position higher than arbitrator, a state position higher than that. The cases were assigned to these arbitrators by lottery. The ancient Greek arbitrators would first attempt to resolve cases amicably. If they couldn't do that, they would move on to resolving the disputes using more formal procedures, for example, by calling witnesses, overseeing the submission of evidence in writing. You could take an appeal from these arbitrators to the College of Arbitrators, who could, if they had to, refer the matter to the formal courts. So this whole system sounds somewhat familiar, even though it's 2,500 years ago. Both Aristotle and then later Cicero celebrated arbitration for reasons that still ring true today. Aristotle said arbitration gave equity its due weight, making possible a larger assessment of fairness. Cicero said a trial is exact, clear-cut, and explicit, whereas arbitration is mild and moderate. Adding that a person going to court expects to win or lose, but a person going to arbitration expects not to get everything, but not to lose everything either. What was true for the ancient Greeks thousands of years ago is still true today. No formal legal system can or should resolve all of its people's disputes. In the intervening millennia, nearly every culture and country has adopted some form of extrajudicial dispute resolution. In the United States, modern ADR was born in the early 20th century and has grown tremendously in its use and prevalence since, and for good reason. ADR not only affords procedural benefits like relieving overburdened courts, but it can also produce substantively better outcomes, particularly if measured by the party's satisfaction with the combination of process, cost, and result. Take, for instance, mediation. Mediation can save the parties the expense and stress of protracted litigation. It can allow parties to drive the process of resolving their conflicts, which maximizes the likelihood that their interests and positions will be heard and their needs will be met. Parties are free to explore creative solutions outside of the scope of traditional legal remedies, and they can usually resolve their disputes through mediation faster than they would in court. In addition, parties are more likely to keep agreements reached through mediation and to preserve a positive ongoing relationship with one another. And even when parties don't reach an agreement through mediation, it's still a productive exercise, often narrowing the scope of the factual and legal disputes. Indeed, today, in the great majority of commercial and tort cases, sophisticated counsel, often aided by mediators or other neutral facilitators, arrive at settlements in which right and wrong are not ultimately adjudicated. Having resolved their disputes outside of the courtroom, the parties walk away with something to which they both have agreed. Although many people I meet are not aware of it, for the past several decades, the unified court system has been making small but consistent steps towards incorporating the fundamental principles of ADR more generally throughout the court system. by piloting and sustaining myriad problem-solving courts. I use the phrase problem-solving here somewhat as a term of art. Problem-solving courts look to the underlying issues that bring people into the court system and employ innovative approaches to address those issues. In fact, today we have more than 300 problem-solving courts across the state, which include community courts, drug courts, mental health courts, and veterans courts. The successes of those courts has been astounding. At the 2024 State of the Judiciary Address, which we held across the street in the Court of Appeals Hall this past February, I shared the stage with three incredible individuals who shared their experiences in some of our state's problem-solving courts. I can't possibly explain the impact, both societal and personal, of those courts nearly as well as the people who spoke about their firsthand experiences in those courts. So if you're interested to see and haven't already seen how those principles work and how those courts work, and how the principles that are at the core of ADR are being incorporated into matters that otherwise would be processed through the traditional criminal justice system and criminal courts, watch the video of the speeches of those three people during the State of the Judiciary Address. You can find those on the Court of Appeals website. For me, their stories represent not what is typical, but what is possible in the court system when we focus less on punishing and more on solving the problems of the individuals who appear before our courts. Just as some civil cases must be litigated to conclusion, some criminal cases must be tried to a verdict or resolved by a guilty plea, but some, whether criminal or civil, can be better resolved by ADR principles in which all affected parties work towards a result they can all support. For that reason, in the little more than a year that I've been Chief Judge, we at the Unified Court System have embarked on an important shift in the way we are thinking about the judiciary. We've begun to think about all courts not as places that solely adjudicate right and wrong, but as places that can solve problems. Traditionally, we think of courts as asking questions like what law was broken and who should be punished and who did something wrong. But what if all of our courts made space for questions like who has been affected, what are the needs and responsibilities of all affected persons, and how do the parties together address the needs and repair the harm? As evidenced by the resounding success of ADR, and as evidenced by the resounding success of our 300 problem-solving courts, when courts act as problem solvers, outcomes are better and our communities are safer and stronger for it. Although the paradigm may seem unusual to the general public, I believe it will feel familiar to people, I was going to say in this room, but in this lovely outdoor space. Because the inspiration at the heart of this shift is thinking about courts as problem solvers. The heart of it is ADR. For as long as civilization has existed, we've been trying to find ways to resolve our disputes peacefully with creativity and thought and mutual understanding. As we nurture the ADR ethos throughout our entire court system, it's vital that our formal ADR processes remain strong and continue to expand. To that end, just a few months ago, Lisa Courtney took on a new role in the court system, Director of the Office of Court Administration's newly formed Division of Alternative Dispute Resolution, which will work to further the Unified Court System's efforts to significantly expand the development and use of ADR programs, online tools, and other resources to better meet the justice needs of New Yorkers statewide. In addition, we've adopted new rules that will strengthen our existing ADR infrastructure. Among other improvements, our new Part 160 requires New York courts to refer civil disputes as early as practicable to an appropriate ADR process unless certain circumstances preclude the referral, which will improve the parties' access to alternatives to litigation in civil and family cases. I do want to thank everyone tonight for your long commitment to and passion for alternative dispute resolution and for giving me a few minutes of your time this evening. I hope you will partner with the court system, as you have always done, by helping us to integrate ADR into your litigation practices, by being in conversation with Lisa and her team about new ways to improve and streamline ADR in New York, and by adopting a problem-solving mindset when thinking about the role of New York courts generally, a mindset that is firmly rooted in the history and success of ADR. Thank you all very much.
Happy with this case.